President Trump just scored a massive legal victory that could reshape presidential power in America. And it's happening right now in Portland, Oregon. What does this mean for your constitutional rights, state sovereignty, and the future of federal authority? On October 20th, a federal appeals court handed President Trump a critical win in what may be one of the most consequential battles over presidential power we've seen in years. The Ninth Circuit Court of Appeals, in a 2-1 decision, just ruled that Trump can deploy federalized National Guard troops to Portland, Oregon, overturning a lower court judge who said absolutely not. Here's what happened. Back in late September, President Trump issued an order federalizing 200 members of the Oregon National Guard to protect a federal ICE facility in Portland. Local officials, including Oregon's governor and attorney general, immediately sued, arguing the president was overstepping his authority. U.S. District Judge Karen Immergut sided with them on October 4th, blocking the deployment and saying Portland's situation was not significantly violent or disruptive enough to justify federal troops on the streets. But now the appeals court disagrees. 2 Trump-appointed judges, Ryan Nelson and Bridget Bade, wrote in their majority opinion that it is likely that the president lawfully exercised his statutory authority. They pointed to violent protests that occurred in June, July, and August outside the ICE facility, including a riot declaration and the facility being forced to close for over 3 weeks. So, what's really going on in Portland? This isn't just about one city. This is about whether a president can send federal military forces into American cities over the objections of state and local leaders. The administration says protesters have been violent, threatened federal officers, and created chaos. Oregon officials say the protests have been mostly peaceful, with some demonstrators literally wearing chicken suits and inflatable frog costumes. Judge Susan Graber, appointed by President Clinton, issued a blistering dissent. She wrote, "Given Portland protesters' well-known penchant for wearing chicken suits, inflatable frog costumes, or nothing at all when expressing their disagreement with ICE methods, observers may be tempted to view the majority's ruling, which accepts the government's characterization of Portland as a war zone, as merely absurd." She went further, saying the decision erodes core constitutional principles, including sovereign states' control over their state's militias. But here's the complexity you need to understand. While the appeals court lifted one restraining order, there's still a second order in place that blocks the deployment of National Guard troops from any state into Oregon. So even though this is a legal victory for Trump, boots aren't hitting the ground just yet. The administration filed papers Monday evening, asking the court to dissolve that second order too. White House spokesperson Abigail Jackson praised the ruling, saying, "President Trump is exercising his lawful authority to protect federal assets and personnel following violent riots that local leaders have refused to address. This ruling reaffirms that the lower court's ruling was unlawful and incorrect." Oregon Attorney General Dan Rayfield fired back with a stark warning. Today's ruling, if allowed to stand, would give the president unilateral power to put Oregon soldiers on our streets with almost no justification. We are on a dangerous path in America. Now let me give you the other side. The Trump administration argues they're using existing federal law, specifically 10 U.S.C. Section 12406, which allows the president to federalize the National Guard when he's unable to execute U.S. laws with regular forces. They point to months of protests, threats to federal officers, property damage, and the fact that the ICE facility had to shut down for weeks. They say local authorities refuse to handle the situation, leaving federal personnel vulnerable. The state of Oregon and city of Portland counter that this characterization is wildly exaggerated. They argue the protests have been manageable by local police, that the situation doesn't meet the legal threshold for federal military intervention, and that Trump's characterization of Portland as war-ravaged is, as Judge Graber put it, simply untethered to the facts. Here's what makes this case so important for every American. If this ruling stands, it could dramatically expand presidential power to deploy military forces domestically. Think about it. If a president can federalize state National Guard units and send them into cities based on protests, even when state governors oppose it, that's a fundamental shift in the balance of power between federal and state governments. And Portland isn't alone. Trump has also pushed for National Guard deployments in Los Angeles, Chicago, Memphis, and even threatened San Francisco. This is a pattern, not an isolated incident. The administration is testing how far presidential authority extends when it comes to domestic military deployments. What does this mean for America? First, it sets a precedent that future presidents, Democrat or Republican, could use. If you support this move because you agree with Trump's immigration policies, ask yourself, would you want the next president to have this same power? Second, it raises serious questions about the 10th Amendment, which reserves powers not given to the federal government to the states. Can a president override a governor's authority over their own state's National Guard? If you're asking, should the president have the authority to send federal troops into American cities over state objections? That's the constitutional question at the heart of this case. The majority says yes, when federal property and personnel are threatened. The dissent says no. This violates state sovereignty and First Amendment rights. Here's what happens next. Oregon officials have already asked for an en banc review. That means they want all 11 judges on the Ninth Circuit to reconsider the case, not just the 3-judge panel. Interestingly, one of the Ninth Circuit judges already asked the court to vote on whether to rehear the case, which is unusual. Both sides have until midnight Wednesday to make their arguments. Meanwhile, those 200 Oregon National Guard members? They've been federalized and sitting in a holding pattern for weeks, pulled away from their families and jobs with no clear mission. Governor Tina Kotek said she's very troubled by the court's decision and called the deployment unwanted and unneeded. Let's talk about what's at stake beyond the legal technicalities. This is about the relationship between citizens and their government. It's about whether protest, even disruptive protest, can be met with military response. It's about whether federal authority trumps state sovereignty when the two clash. And it's about whether courts will serve as a meaningful check on presidential power or defer to the executive branch's judgment about military necessity. Before we go further, if you're finding this analysis valuable, hit that like button and subscribe to Politics Tribune. We're bringing you the facts the mainstream media won't cover, and that notification bell means you'll never miss a critical update like this one. The White House argues this is about protecting federal employees and property, a legitimate federal interest. They say when local authorities fail to maintain order around federal facilities, the president must act. They point to evidence of violence, officers threatened, property damaged, arsons, declared riots. From their perspective, this isn't about suppressing peaceful protest. It's about ensuring federal personnel can do their jobs safely. But critics see something darker. They argue this is about intimidation, about sending a message to sanctuary cities that resist federal immigration enforcement. They worry it normalizes military presence in American streets for political purposes. Portland Mayor Keith Wilson said, "Portland stands for democracy, dignity, and the right to peacefully protest. Our focus is simple and unchanging. We demand transparency, accountability, and community-led solutions, not troops on our streets." Here's the legal principle the court grappled with. How much deference should courts give to presidential military decisions? The majority said the president's judgment about military necessity deserves a great level of deference. The district court had said deference doesn't mean ignoring the facts on the ground. This tension between respecting executive authority and providing meaningful judicial review is exactly what makes this case so significant. Should the full Ninth Circuit overturn this decision? Should the Supreme Court ultimately weigh in? These questions matter because similar cases are playing out in Chicago, Los Angeles, and potentially other cities. The legal framework established here will apply nationwide. Think about the bigger picture. We're watching a real-time test of American federalism. The Constitution divides power between federal and state governments for a reason. The founders feared concentrated authority, but they also gave the federal government specific powers to maintain order and execute federal law. When those principles collide, who wins? The appeals court majority focused on legal authority. Does the statute allow this? They concluded yes, pointing to evidence of violence and disruption from June through August, even if September saw calmer protests. The dissent focused on constitutional principles. Just because a statute might technically permit something doesn't mean it's constitutional when it violates state sovereignty and potentially chills First Amendment rights. From a pro-America perspective, here's what I see. Our Constitution works because it balances competing interests: federal versus state power, security versus liberty, executive authority versus judicial oversight. This case tests all those balances. I believe in strong federal authority to protect federal personnel and property. If ICE agents can't safely do their jobs because local authorities won't maintain order, that's a problem the federal government can legitimately address. But I also believe in the 10th Amendment and state sovereignty. Governors command their state's National Guard for a reason. The founders designed our system so that military force, especially domestic military force, requires checks and balances. No president should have unlimited authority to federalize state militias and deploy them against the wishes of state leaders without meeting a high legal bar. So what's my take? The evidence matters. If Portland genuinely saw sustained violence, property destruction, and threats to federal personnel that local police couldn't or wouldn't address, then the legal authority exists for federal intervention. But if the administration is exaggerating the threat level to justify a military response to protests they politically oppose, that's a dangerous precedent that should concern every American regardless of party. You need to understand the stakes. This isn't just about Portland. It's about whether future presidents can deploy military forces domestically based on their characterization of local conditions, even when state and local officials disagree with that characterization. It's about whether courts will meaningfully review those decisions or simply defer to executive branch claims. The next 48 to 72 hours are crucial. Watch for 1. Whether the Trump administration successfully gets the second restraining order dissolved. 2. Whether the full Ninth Circuit agrees to rehear the case en banc. 3. Whether Oregon or the city of Portland appeals to the Supreme Court. And 4. Whether similar cases in other cities follow this precedent or establish different legal standards. Comment below, yes or no. Should President Trump have the authority to deploy National Guard troops to American cities over state objections? And tell me why. I want to hear your reasoning, not just your conclusion. This is the kind of constitutional question that shouldn't break down purely along partisan lines. Here's my bottom line. Strong federal authority to protect federal interests? Absolutely. Presidential power to override state sovereignty based on contested characterizations of local conditions? That requires scrutiny. Courts serving as a meaningful check on executive power? Essential to our system. The Ninth Circuit just said the president likely has this authority, but with one judge dissenting strongly and the full court potentially reviewing the decision, this legal battle is far from over. America's strength comes from balancing federal power with state rights, security with liberty, just executive authority with judicial oversight. This case tests whether those balances still work. The coming days will tell us whether our constitutional system provides meaningful limits on presidential power, or whether, as Oregon's Attorney General warned, we're on a dangerous path. What do you think? Are we protecting federal authority and personnel, or are we normalizing military responses to political dissent? Drop your thoughts in the comments, and let's keep this conversation civil and substantive. This is too important for shallow takes.
If you enjoyed the video, hit the subscribe button and turn on notifications so you don't miss any new videos.